Court action is the other main means of dealing with a construction dispute through a litigious process. It's well suited to more complex disputes, professional negligence disputes as an example. It involves a far more detailed analysis of the evidence and the facts. And it can take a significant amount of time to go through. I mean, you can be looking at a start to finish of 6 to 12 months quite easily, possibly longer. So if you compare that to adjudication at 28 days, you can see why adjudication is quite popular for more minor disputes or easier disputes. Court action is most suitable for complex disputes, any particularly involved contractual disputes, and particularly, in my view, professional negligence disputes, i.e. claims against surveyors, engineers, architects, where there has to be a detailed examination of the facts, and the court will reach a decision having heard the evidence. In an adjudication, as I say, the evidence quite often isn't actually heard, it's simply on paper. The decision as to whether or not a claim is pursued through adjudication or court action is ultimately down to the client. Obviously, as a solicitor, you provide commercial advice as to which is the best route to pursue, and that will depend very much on the complexity of the case. If, for instance, you're looking at a simple claim for payment by a subcontractor who is still undertaking the works potentially on site, you would always look to an adjudication, in my view, because it's a quick and ready means of resolving the dispute. And it won't hold up works. If, however, you're looking at something more complex, then I would always consider court action. Adjudication really is for the most straightforward cases.